Hello, as the room fills up, I'm just going to give it a few minutes. Thank you for being patient. And I have,
Okay, now we're good.
thank you, Jeff, for joining us. We are live with our attendees joining the room now. So I'm going to wait a few minutes to let the attendees all get online because they're being added one by one. And then we will go ahead and get started.
Great.
Okay, it looks like the room is filling up. So I am going to go ahead and get started. And welcome to our webinar. We're talking about navigating financial stress issues with small business clients, and we have a variety of legal professionals on here. I'm Jen Lee. I'm going to be talking more on the consumer and small business owner side of things. And then we have Jeff Lerman, who is going to be talking about all of the fun things that have to do with asset protection. And Ben Young is going to be talking about emergency protections under state law for evictions, expansion of the Small Business Reorganization Act, and other legal options available. And finally, Philip Diamond will be talking about commercial leases and COVID-19. So all very timely topics these days. So I will say, as a couple of housekeeping items, there is a lot of information coming at you during this. If you have questions, I would recommend that you email the panelist who is introducing that topic. We do have a lot of information and we probably will go past 1:30. So if you want to hang out, you can. This is being recorded, so there will be a recording available as well if you cannot hang out and listen to the rest of the presentation. And of course, as lawyers, we all have our legal disclaimer that this presentation is not legal advice specific to any situation, and our content is believed to be accurate at the time of the presentation. But as you know, things are changing very rapidly with the COVID-19 status. And so things may change while we're in the presentation, which did happen to me last week. So my name is Jen Lee, and I am a debt and credit attorney. And I help a lot of individuals and small business owners deal with financial stress. And the reason why I have an elephant in my background and on the screen is 70% of Americans have a debt or credit problem of some sort, and nobody really wants to talk about it. Everyone thinks they're alone. And so I do use this elephant, and her name is Burn a Debt, as a tool to talk about some pretty tough issues. And it's a little bit kitschy, but I do find that most people think finances are a pretty individual thing and very emotional. So financial stress is affecting everyone right now, business owners included. And employees, if you have employees in your company, there's a huge impact to the bottom line of a company when employees have financial stress. And so it's estimated at $7,000 per year per employee that companies are losing in productivity due to their employee financial stress. And right now that's magnified. They're going to be increasing financial stress, unemployment options. So the point of this is, how do we talk about it? So even in good times, business owners need tools and resources. So talking about financial stress, it's a sensitive topic. I do talk a little bit more about the emotional side of things than, going through a little bit more about the emotional side of things, because even though we're business owners and we want to be very official, and lawyers tend to be very, heavy on the legal terminology, it's a really sensitive topic and it's hugely emotional. And a lot of business owners and a lot of your clients are doing things that don't always make sense because they think that's what they should be doing from bad information. So it's a really sensitive topic. It's hard for financial advisors. It's hard for a lot of people to open up about the topic. So I often will talk through what the impact is on productivity and relationships and health when it comes to financial stress as a way of opening that dialogue. So if you're talking to a business owner and you're talking about their productivity issues in the workplace, there are all kinds of studies that have been done on how much financial stress impacts the workplace. A lot of people think financial literacy is the problem, and it's actually not. People need solutions before they can take advantage of proactive options. Relationships, health, a lot of stress these days, health issues are caused by financial stress. So when you're talking to your business owner clients and you're talking to individuals who are stressed, be prepared with information. We have a lot of resources, a lot of links to things on my website. At the end of my portion here, I will link to my website. There's COVID-19 resources, there's regular resources, because you really need to help your business owner clients, even individuals, high net worth individuals, often fall for scams or quick fixes. I can't tell you how many people I've had come in who have net worths in the $5-10 million range that have fallen for a scam or a quick fix. And a lot of times it was because they were embarrassed to ask for advice. They thought, oh, I should know this. So the emotional side of things makes it hard to talk about financial stress. Okay, so now I'm going to go into an overview of all of these new programs that are out there for individuals and small businesses under the broad term of the CARES Act, which was passed on March 27th. There has been so much information that has changed over the last 3 weeks. There have been new things announced. I think when I was updating the PowerPoint this morning, I had to change things because there are things that changed. So just keep in mind that this is very fluid. One of the items in the CARES Act, and I'm not going to touch on every single part of the CARES Act because it was 880 pages, but payroll taxes is always interesting because a lot of small business owners I talk to have some problems sometimes paying taxes. Like we usually get to the end of the year and they're like, oh, I don't have enough money for taxes. I paid all my employees, but I don't have enough money for taxes. What the CARES Act did was it gave us the opportunity for business owners to defer 6.2%, which is your Social Security payroll tax for the employer side, from March 27th through December 31st. It's deferred, it's not forgiven. And so you do have to repay it, and it has to be repaid 50% by December 31st, 2021, and the remaining 50% by December 31st, 2022. I would encourage accountants and financial advisors to talk to your clients about how they plan on repaying that. Because what I have found is kicking the can down the road sometimes isn't a benefit. So keep that discussion going if they're going to defer payroll taxes, how they're going to repay it. Because if they defer $50,000 and they're going to pay it back over the next 2 years, that's $2,000 a month they're going to have to come up with. So it depends on the business, but make sure you're talking to your clients about how they plan on repaying that. I know that's not a fun topic. And then there's been all kinds of news about these economic impact payments and who's getting them and who's not getting them and how they're being direct deposited and if you have to file a tax return and all kinds of crazy things. So the basic parts of it is the $1,200 is allowed for individuals if you made $75,000 or less in 2018 or 2019. So basically they're looking at tax returns. If you have not filed 2019, they're looking at 2018. If you filed 2019, they'll look at 2019. So $2,400 if you're filing jointly. If you're filing as head of household, I think it was $112,500 is the cap on it. And then $500 for each eligible dependent. The easy part was looking at the numbers. The hard part is actually getting this done. And I know a lot of people are depending on these funds coming in. So the direct deposit was supposed to start this week. I did hear from various clients and business owners that they did receive direct deposits if they had gotten a refund in 2018 or 2019. If you did not get a refund and the IRS doesn't have your direct deposit information on file, then they are supposed to be setting up a website where you can go in and put in your direct deposit details. My understanding of that is that it's been very overloaded and that a lot of people are getting payment statuses that say payment status not available. And that usually is happening if you haven't filed your 2019 tax return. So even if you filed 2018 and you qualify for it, then they're still getting that statement. So from an employee standpoint, people are checking constantly to see when their economic impact payments are coming in. And it's changing constantly with things. Part of the CARES Act too talks about retirement accounts, and as financial advisors advising people that you can take out $100,000 out of retirement without penalty scares the you know what out of me, because as I'm sure most financial advisors will agree, cashing out money from a retirement account, taking out money is usually not a good idea unless there's an extreme circumstance. So the reason why I say use caution here is because if you're advising your business owners and your clients to take money out of retirement accounts, just look at long term. So you're allowed to take $100,000 out of retirement account without that 10% penalty, and it's through December 31st of 2020. So it's through the end of this year. There is a certification you must have been impacted by COVID-19. I don't know how you could not be impacted. I think we've all had some kind of impact. So as a lawyer, I'm pretty sure all of us could argue that there was some kind of impact. And you are allowed to repay for 3 years from the date of disbursement. So that is a good option. But again, I caution people when they see the retirement accounts, you can cash it out, people thinking that they should do that. And then student loans. A lot of my business owner clients have student loans. I work with a lot of law firms, a lot of doctors and dentist offices, and they have significant student loans. So part of the CARES Act goes into the deferment of federal student loans through September of 2020. They're suspended at 0% interest, and it's automatic. If you log into your MyFed loan account, it's on there, no payment due till September 30th at 0%. There is a gotcha here. They have to be federal student loans, and they have to be serviced by the federal government. There are about 9 million loans sitting out there that are privately serviced that do not qualify for this. So if your clients have student loan issues, or they have student loan issues for their kids, a lot of times I get financial advisors who have clients with kids with student loans. Be careful and make sure that they actually are deferred through at 0% interest. There is supposed to be no delinquent reporting on credit reports for the student loans through September 30th if it's a federal loan. And so if it's a private loan though, you're gonna have to call and make arrangements for whatever program that they're offering, if they're offering anything. And then employers, business owners can contribute up to $5,250 tax-free to assist employees with student loan payments. And that was part of the CARES Act. So that's a pretty good benefit if you're able to help your employees with paying student loans. Okay, so a lot of this has changed this morning. Getting into the SBA lending that came with the CARES Act is the Paycheck Protection Program, which everyone's calling the PPP. And basically, well, it's kind of been a mess. $350 billion was set, or $349 billion was set aside to keep business operating with their payroll and other essential business expenses. They were supposed to be federally guaranteed loans to small business and nonprofits through banks. It wasn't directly from the SBA. And the reason why most business owners should be looking into this is the loans may be forgiven if they're used correctly. Now, the guidelines changed on this about 13,000 times. They changed daily, they changed hourly. The application was supposed to be available April 3rd. A lot of people didn't have the application, a lot of banks didn't have the applications. So it has been kind of a mess. As of this morning, the Wall Street Journal was reporting that all funding under the PPP has been spoken for. So if someone does not have an SBA loan number already, then we need to wait for additional funding on this. So I'm going to go through who is eligible. If you have business owner clients who are interested in the PPP, they should still apply, because if more funding comes through, it's first come, first serve. And if they have their application in process, then they'll be next in line. So for eligibility, it has to be a small business with fewer than 500 employees, or 501c3, which was interesting that they threw in nonprofits with fewer than 500 employees. You're also eligible if you are a sole proprietor, if you're an independent contractor, or some type of gig worker are technically available for the PPP, but it's hard to qualify that way. But if you're self-employed, you do qualify for PPP. Who is not eligible? If you are engaged in a federally illegal activity, such as cannabis, I know for all of us with cannabis clients, It's not available for PPP lending. Also in Nevada, gaming can only be 33% of your gross revenues. You can't pay household employees. So if you're a household employer where you have a domestic, either a housekeeper or a nanny, that kind of thing, that's not eligible for this. If you've defaulted on a federal loan in the past 7 years, which could be student loan, could be another SBA type loan, you don't qualify. And then bankruptcy, which I am a bankruptcy attorney. I do a lot of debt and credit work. The application, the CARES Act itself does not say that bankruptcy is a disqualifier. However, the guidelines seem to indicate that if you've filed for bankruptcy or are in an active bankruptcy, that you don't qualify. So that has been interesting to figure out whether banks will lend or not under the PPP. In order to qualify, you do have to certify that you've had a break in your operations of some sort. Again, I don't know how anyone could probably say that they haven't had some kind of impact from COVID-19, that you're going to use the loan proceeds to pay workers. So the point of this, and it was mostly to keep payroll going. One of the problems that's come in for some small business owners is that if someone makes less than $50,000 a year, it's almost better for them to be on unemployment with the new increased federal unemployment. So I have talked to a lot of business owners in the last couple of days who have had problems getting their employees to actually want to come back under the PPP because they're getting paid more on unemployment. So I heard of a couple that had withdrawn their PPP loans because they didn't think they could get them forgiven under the requirement that it has to be used for payroll. You had to have been in business as of February 15th, 2020 and had employees that you paid salary or independent contractors. And you cannot receive another loan under PPP. So it's a one and done type deal. There have been lots of discussions on how to advise people on the amount and the term of the loan. I am not going to get too far in the weeds on this. I just want people to realize what these numbers look like so that I can pass this off to Ben to talk about some small business reorganization stuff. But basically the loan amount is 2.5 times your monthly average payroll costs. And that's as far as I'm going to get into it, but there's been a lot of interesting calculations out there, what's included in payroll, what's not included. So there is no collateral, there's no personal guarantee required on these loans, which is interesting for an SBA type loan. And if you have an economic injury disaster loan, it can be rolled into this. The first payment under PPP is not due until 6 months after disbursement. And so what can a loan be used for? In order for forgiveness to apply, you have to use it for payroll costs, health insurance expenses, mortgage interest, rent, utilities, debt that you had incurred before February 15th of 2020. You can use it to pay the interest expense on that. And the maximum amount, I did a quick calculation on here, and I will send slides out to everyone as well. But basically, they looked at your aggregate payroll costs for 2019. You're supposed to subtract out anyone who makes more than $100,000, the difference, $100,000 up to the cap, and then divide it by 12 to get your average monthly payroll costs, and then multiply it by 2.5 to find out what your loan amount is supposed to be. There's been a lot of discussion of what goes into these numbers. The same thing for payroll costs, salaries, vacation, health insurance benefits, retirement benefits, all of that goes in. Most of the payroll companies out there, Gusto, Paychex, if you have ADP, things like that, they have one-click reports that are being used for some of these so that you can gather all this together and do a quick spreadsheet. So I'm going to skip through some of that. Forgiveness. The important part when you're advising your clients on forgiveness is that you have to document all of this. Forgiveness will be reduced if you use more than 25% on non-payroll expenses, if you don't have the same number of employees that you started with under the PPP, if you don't use the proceeds within 8 weeks, you're going to limit your forgiveness. So my advice for clients, document, open up a separate bank account to put the loan funds in, make sure that you are listing out every single expense and can justify all of it, because the guidelines on forgiveness have not been fully outlined. So make sure that you have proof of everything that you've done so that you can get the maximum forgiveness when you're advising clients. Just very briefly, the economic injury disaster loan was the one directly on the SBA's website. It is my understanding as of this morning that they have cut access to that because funds have been maxed out. And that was supposed to be up to $2 million. They changed it last week to $15,000 was the max. When you're discussing options with clients, I do a lot of talking about what people should be doing with mortgage, credit reporting, credit cards, car loans, private student loans, and taxes. The most important thing for mortgages and for rent is to talk to whoever your lender is or your landlord. Make sure that your clients are talking to their mortgage companies and finding out what the terms of any forbearance options and deferment are. What happened back in 2008, 9, and 10, sometimes payments got deferred for 3 or 4 months, but then the entire amount then was due on the 5th month or the 4th month. So understanding all of those terms and helping your clients understand what that means, because I don't want to end up in 3 months where there's a mass set of foreclosures coming in. Lots of information out there regarding foreclosures being delayed or a moratorium. I do have a resource on my last page here that talks about the Consumer Finance Protection Bureau has a really good mortgage relief summary. So make sure you're looking at trusted resources on when you're advising clients on this. So consumerfinance.gov has a COVID-19 mortgage relief page that tells you how to find out if your mortgage is government backed and then what the terms are of those moratoriums that are in place. The U.S. House Committee also has a frequently asked questions on the CARES Act that I found very useful. And then also make sure that you're reaching out to your trusted colleagues, those of us on this webinar, your accountants, legal, financial services, to figure out what's going on. My fear and what I've heard from people so far is the number of scams, people trying to say, oh, I can get you your CARES benefits faster if you pay me or if you cut me a check. So that's what I'm mostly concerned about right now with business owners as well. And feel free to email me, jen@genleelaw.com if you have any questions. My website does have a COVID-19 special resources list as well. So I am going to, my 30 minutes and that really, really quick rundown there, I am going to turn this over to Ben Young. And Ben is an attorney at Mangels, Butler, and Ben, I'm going to mess this up. Mitchell. I'm sorry, Ben. I got it right yesterday. But Ben is a great corporate restructuring and business attorney, workouts, bankruptcy as well. So I'm going to stop my screen share and turn it over to him and let him take it away.
All right, good afternoon, everyone. I'm Ben Young. As Jen mentioned, I'm a partner with the law firm of Mangels, Butler, and Mitchell. I'm a bankruptcy lawyer, and I specialize in insolvency matters for mid-sized businesses, middle market companies. So I handle complex matters that involving distressed middle market companies. A lot of bankruptcies, a lot of workouts, restructurings, assignments for the benefit of creditors, matters of those type. And so I wanted to talk today about some of the issues that small businesses should know about, some of the things that small businesses should know in these unprecedented times, because there have been a lot of changes in the law and in various actions that the courts have taken to deal with the financial crisis driven by the coronavirus. So what I want to talk about first will be the emergency moratoriums that the California courts have put in place. And then I want to talk about the expansion of the Federal Small Business Reorganization Act that was part of the CARES Act, which I think is an important piece for small businesses. And then I want to just briefly mention that a lot of the local courts are closed, as many of you who are lawyers probably know, which has some impacts as well. So first, with respect to the emergency rules the courts have enacted, the Chief Justice of the Supreme Court issued of the California Supreme Court issued an emergency rule that basically bans unlawful detainer actions, residential or commercial, statewide, except if there's a public health or safety issue involved. So this just puts the brakes on any kind of eviction action that a landlord might want to take against a commercial tenant that's unable to pay rent due to the virus. What's interesting is the duration of the ban. It's a 90-day. It's 90 days after the governor declares the end of the state of emergency. And it's very unclear when the state of emergency is going to end. It could well be extended. It could go for a long period of time. And then the ban on unlawful detainer actions is going to go on for 90 days after whenever the governor declares the state of emergency at an end. So this could be with us for quite a while, and that's an issue for commercial property owners. It's also an issue for tenants to be thinking about. The second emergency rule that the court came out with was to basically ban judicial foreclosure actions. Judicial foreclosure proceedings are now stayed, again, until 90 days after the governor declares the end of the state of emergency. There's also the public health or safety exception. But this basically puts the brakes on all judicial foreclosure proceedings. And we'll talk in a minute that doesn't encompass as many foreclosures as you might think. And in fact, it probably doesn't capture very many at all because most foreclosures in California are not done judicially. And it also only appears to apply to real property foreclosures, not to a judicial action to foreclose on personal property. So this one may be somewhat limited. But again, we have the same issues with duration, 90 days after the governor declares the end of the emergency. Now, there's a couple important points to note, and I think Jen alluded to one of them. These are moratoriums. They're only a delay in the exercise of rights. It's the can kicked down the road, potentially for a long time, but there's no forgiveness and there's no repayment schedule. So once the moratorium ends, the money's owed and the creditor is going to have the right to exercise whatever rights they might have. So if a tenant, for example, doesn't pay rent for a long period of time and then the governor declares the emergency over, in 90 days, that tenant's going to have to come up with a significant chunk of money or be at risk of an eviction proceeding at that time. So it's helpful in the short term, but without a repayment schedule, there's a cliff at the end of this. The other issue that's a little unclear is what happens with late charges or default interest. Neither of these rules mention either of those, so it is possible that a landlord or a lender could insist on late charges or default interest for whatever payments aren't made during the course of the moratorium. And we'll talk about this a little later, but it seems to me that with both of these, what they do is force the lender and the borrower, or the tenant and the landlord, to talk to one another. The tenant has some protections, the borrower has some protections, but the money is still owed and it's still going to have to be paid at some point. Obviously, the lender or the landlord has incentives to get the cash flow going. So there's definitely an incentive for both parties to try and work together and come up with their own solution. Another important limitation is that the foreclosure bar applies only to judicial foreclosure on real property. As I mentioned, most foreclosures in California are done through a private procedure with a notice of default, or NOD. And there's no bar to a lender proceeding through that process. Now, I guess one could ask a question of how that really could be done, how one could conduct a foreclosure sale if there's a ban on any gathering of more than 10 people. The idea of a foreclosure sale is an auction that is supposed to be well attended. And there's also issues with how can due diligence on the property be done. So there's a question of whether one could really do that as a lender, but certainly they have the right to proceed with an NOD if they elected to do so. There's also no bar to a foreclosure on personal property, either judicially or through a private sale process under the Uniform Commercial Code. I guess a question would be, again, if one was trying to proceed in a private foreclosure sale on personal property under the Commercial Code, there's an obligation to proceed in a commercially reasonable fashion. And is a sale in these times commercially reasonable? Is it possible to do that? I imagine you could have an online auction and have some kind of online process, but how would parties do their due diligence? How would they go and look at whatever it is that's going to be sold? And a last practical impact is whether a lender can get a receiver appointed. As many of you know, one of the reasons judicial foreclosure proceedings are brought is so a lender can get a receiver appointed to collect the rents from a distressed piece of property. And if there is a stay on judicial foreclosure actions, can a lender file such an action and get a receiver appointed? There may be some workarounds in terms of how you actually plead it, but and it may depend on how broadly the courts and the clerk's office view these rules. But I think there is very much a question mark as to whether a lender with a loan in default, whether they can get a receiver appointed, which would be one of their traditional remedies. There also are a number of local moratoriums that have been enacted by cities and counties throughout the state. I didn't want to go through all of those because there's great variety and a large number of them, and it's very local. But I thought the Oakland eviction moratorium was interesting because it seems to go farther than any of the others that I've seen. Oakland has adopted a moratorium on commercial evictions, and the ordinance provides that a small business tenant cannot be evicted ever for non-payment of rent that became due during the emergency if the non-payment resulted from a decline in business as a result of the emergency. And they specifically state that the tenant's not relieved of the obligation to pay rent, but they can never be evicted. They have an absolute defense under the terms of the ordinance to an eviction action if the non-payment resulted from a decline in business as a result of the shutdown. And small business here means 100 or fewer employees and 15 million or less in revenue. So a decent sized company, not a huge company, but a decent sized company. And so it'd be interesting to see how that plays out. If a landlord can't ever evict the tenant for non-payment, but the tenant still owes the money, it could be interesting in seeing how that plays out. But I think this is a very important protection for tenants in Oakland, at least, that goes well beyond the moratorium and the emergency rule that the court has put in place. And as I mentioned, the local courts, the state courts are temporarily closed. The exact date when they're scheduled to reopen varies county by county. I would expect many of those dates are going to get pushed out depending on the speed at which the state reopens. But I think the courts are likely to remain closed. I think they're scheduled to be closed in most cases through May, and I would expect those dates to be pushed out. As a practical matter, this is a moratorium on payment of debts, because if you can't be sued to collect the debt because the court's closed, then effectively you have a moratorium, at least until the courts reopen. The federal courts do remain open. I've had a number of hearings in the bankruptcy court in the last month. Those remain open. Everything is being done telephonically. No one can go to the courthouse, and the hearings are conducted telephonically. All trials have been postponed. Anything that requires live witness testimony has essentially been postponed. But law and motion matters are proceeding, which is useful in bankruptcy cases because you often have to go to court and get various matters approved by the judge in order for the business to continue. So now I'd like to turn to the Small Business Reorganization Act that was recently expanded, as I mentioned, by the CARES Act. This is a bill that was enacted by Congress last fall and became effective in February, I believe, just coincidentally. The reason for it is that Chapter 11 is very expensive and often, as a result, not real practical for small businesses. The cure can be worse than the disease because the legal fees in a Chapter 11 case, particularly if it's contested, can be tremendous. And so to address this and to make Chapter 11 more practical for small business, Congress enacted a streamlined version available only to small businesses. It was modeled on Chapter 13, which is the bankruptcy chapter for wage earners, and we'll talk about that in a minute. And as originally enacted, there was a debt cap of $2.5 million. So a business with total debt of $2.5 million was eligible for this procedure. And what it allowed was in the normal Chapter 11, if it's very expensive, many small businesses would wind up being liquidated because they just couldn't afford the legal fees. This bill would give a small business a chance at reorganizing itself without incurring those kind of legal fees and continuing in business. But with the debt cap of 2.5 million, it didn't apply to that many businesses. So one of the things that was done in the CARES Act was to expand the Small Business Reorganization Act by raising the debt cap to $7.5 million. Again, this is total debt, so it's secured and unsecured debt, whatever is owed by the business. But if the small business has a debt of less than $7.5 million, then the SBRA is going to be available to it. And the key provisions of the Small Business Reorganization Act is, first of all, just as in a normal Chapter 11, the debtor remains in possession. There's no trustee appointed. So the debtor remains in control, can operate the business. There are provisions for removing the debtor if the debtor has been a bad boy or a bad girl. They can be removed and a trustee appointed. But just like in a Chapter 11 case, the presumption is that the debtor will remain in possession, operate the business, and manage the reorganization process. Secondly, only the debtor can file a plan. Creditors cannot file a plan, so the debtor controls the process, which is huge in a Chapter 11. The debtor, however, must file a plan within 90 days. You can't file one of these cases and sit there forever. You have to get a move on and file your plan within 90 days. There is a very simplified disclosure statement that is used in these small business cases. And that's important because preparation of the disclosure statement is a very large item of expense in a Chapter 11 case. And another big point, and I think this is one of the main ones, is that creditor acceptance is not required to confirm the plan in a small business case. And let me explain why that's important. In a normal Chapter 11 case, the debtor prepares a plan and a disclosure statement, and those documents are sent out to creditors, and creditors vote on whether to accept or reject the plan. Creditors vote by classes, and you have to get at least one class of your creditors to accept your plan. And the purpose of the disclosure statement is to provide adequate information to creditors so they can effectively vote. And that's where a lot of the expense comes in, because a fairly detailed disclosure statement has to be prepared so creditors can vote on the plan. And so you end up with something that looks a lot like an offering memorandum, and the cost of preparing that can be quite high. In the small business case, there's a much simplified form, and while the debtor can proceed through the voting process if it wants to, it doesn't have to. It doesn't have to get creditor acceptance. It doesn't have to have the creditors vote to confirm the plan. One of the issues with creditor voting and confirmation is that if creditors vote to reject the plan, then shareholders basically get wiped out. In a small business, the shareholder is generally the owner of the business. So either the owner of the business has to come to an agreement with creditors and get them to vote to accept the plan, or the shareholder basically gets frozen out. And so that's why a lot of those cases wound up in liquidation, because the business owner couldn't come to agreement with his creditors. Now, in the Small Business Act, you can confirm the plan without the creditor acceptance if the debtor puts all of its projected net disposable income over the next 3 years and uses those funds to pay creditors. And the court has the discretion to increase that period to up to 5 years. Presumption's 3, can be increased to 5. So if the small business debtor puts on the table all of its projected net income for the disposable income for the next 3 years, the court can confirm the plan without creditors really having any say-so in it. They don't have a vote. And disposable income is the income of the business less the expenditures necessary for the continuation, preservation, or operation of the business. Now, these terms aren't defined in the Act, and I would suspect there's going to be a lot of litigation over what exactly those terms mean. I think one of the issues would be in a business, can you have capital expenditures? Can you have reserves for expenses that you expect to incur in the future? Various things like that. Obviously, from the business owner's perspective, you're going to want to push the disposable income down as much as you can so that you pay as little as possible to creditors. I think certainly the business owner would be able to take a salary for services actually rendered, as long as it's market-based. That should be fine. And I would think that some level of CapEx and other expenses that are not direct operating costs would be permissible. But I think there's going to be some fights over that. But if the business puts on the table, as I said, its projected net disposable income, then it can get the plan confirmed without creditors having any right to vote on it. Another important point is that the plan can be modified only by the debtor. Creditors do not have the right to modify the plan. And remember, we're talking about projected disposable income over the next 3 years. The debtor has to pay the projected net disposable income to its creditors. What happens if actual income is less than projected? The statute provides that the debtor may be able to modify the plan to reduce its payments at that point. So if you do worse than projected, then you may be able to modify the plan and reduce the payments to creditors. But the converse is not true under the statute. If actual income is greater than projected, creditors do not have the right to modify the plan to increase the payments. So if the business does better than is projected, the upside is retained by the business owner. It doesn't go to the creditors. And I think that's very important right now in the situation we are in. Again, to confirm the plan, it's projected net disposable income. But in the situation we're in now, projecting future incomes from a business is extremely difficult. We're in unprecedented times. I don't think anyone can really honestly say they know what business conditions are going to look like 6 months from now, or a year from now, or maybe even a month from now. So any set of projections of net disposable income are going to be inherently uncertain at this point, and businesses may do a lot better, they may do a lot worse. But the upside here appears to stay with the business rather than being available to the creditors. So then the practical side of all of this is, first of all, it's kind of an obvious point, is that cash is king, preserve it. But certainly in the bankruptcy setting, a debtor is only as good as much cash as it has. And the more cash it has, the more flexibility it will have and the better the outcome it's likely to see in a Chapter 11 proceeding or even in a small business proceeding. Just much more flexibility if the business has money. Secondly, I think for all business owners, they need to be talking to their landlord, their lender, and their vendors. I probably should put employees in there as well. Their remedies are limited now. You have these emergency moratoriums. The courts are closed, so unpaid vendors can't sue. But they're going to have rights when the emergency ends. At some point, these restrictions will go away, and these parties are going to have rights, and whatever is owed is going to have to be dealt with at that point in time. And so if you're talking now, I think your creditors are going to have more of an incentive to work with you now. First of all, because they likely have others in the same position. If they're a landlord, they have other businesses that can't pay them. If they're a vendor, they probably have other customers who can't pay them. And also, they're going to be experiencing the same stresses. Your creditors have their own set of creditors that they're probably having trouble paying. They've got a landlord, they've got issues with paying. So there's a whole chain here. And so I think a business probably has the most flexibility right now to go out and be talking to its lenders and other creditors and trying to work something out with them on how this is going to be handled between now and the end of the emergency and what's going to happen when the emergency ends. And then if parties are inflexible, there's limitations on the ability to exercise remedies, and there's the Small Business Reorganization Act if you're a business that is under $7.5 million in total debt. That does tie in with what Jen said, though. If one takes the PPP type loans, that could get one over the debt limit. And so maybe I actually got asked this question by a client. Do you take the loan, which takes you out of the Small Business Reorganization Act, but then if you can get it forgiven later, you might drop back down under the $7.5 million and be able to file as a small business at that point. So there's maybe a strategy there where one can take the money, and then when it's forgiven, have the ability to drop back into the Small Business Act. So with that, I think my time is beginning to wind up. I'm happy to answer any questions offline. There's my contact information, and I'd be pleased to chat with any of you either by email or in a quick call if anybody would like to. And with that, I'm going to stop sharing the screen and turn it over to Jeff.
Hey, Ben, quick question that came in on the Q&A, and you said you have a couple minutes left. I'm interested in your take on this. A viewer asked, isn't the Oakland moratorium a taking in a way?
Well, I wondered about that. I didn't want to get too granular in con law and all that. I mean, we have what's called the contract clause in the Constitution, which says states can't make any laws that impair the obligations of contracts. And so there's definitely, and I think that's why in the ordinance they go to such great lengths to say that you still owe the money, and by the way, you really still owe the money. You just can't be evicted if you don't pay it. I mean, I guess the landlord would have a remedy. They could sue for rent. They could file a lawsuit and sue for rent. They just wouldn't be able to terminate the lease and evict the tenant. But I agree. I think there is a constitutional problem with that bill.
Very good. Thank you. Okay, so next we have Jeff Lerman with Lerman Law Partners. Jeff, you want to share your screen?
Unmute myself first there. Hello. Okay, can we see it?
Yes.
Can you hear me and can you see it?
Yes, we can.
Perfect. Okay. Thank you for the time. I appreciate it. So I'm going to be talking about how professional advisors can effectively discuss asset protection with their business and real estate clients. My name is Jeff Lerman. I am an unusual lawyer. I am the real estate investor's lawyer, and I'm also a real estate investor. We help investors with their transactions and litigation. In the transaction area, everything from entity formation to asset protection, which is what we're going to be talking about today, joint ventures, syndication, purchase and sale agreements, loan documents, construction agreements, easement agreements, commercial leases, and litigation that arises in connection with all of those. For those people who may have joined late, I just want to repeat the disclaimer because it is important. Seminar is intended to provide accurate and authoritative information with regard to the subject matter covered. It's offered with the understanding that the speakers are not engaged in rendering legal, tax, or other professional services, and your receipt of this information does not create an attorney-client relationship. If legal, tax, or other expert assistance is required, the services of a competent professional should be sought. The seminar is intended for instructional purposes only. Every effort has been made to reflect the applicable laws as of the date the seminar is originally presented. However, this is a dynamic field in which new laws are enacted, old laws revised and or reinterpreted on a continuing basis, and where statutes, rulings, and case law are constantly changing. So this is a topic that is near and dear to my heart, and I'm passionate about it because since I am a litigator as well as a transactional lawyer, I have seen our clients who end up in litigation. And even though I'm a litigator, I do believe that litigation is probably the worst way to resolve a dispute. And I see what impact it has on our clients. I don't care how smart, how rich, how sophisticated they are. When I see somebody going through litigation, I see a side of them that nobody else really sees. It's a very intimate relationship with the client. And the impact of having to litigate is a very intense for the client, and the consequences of having the opportunity cost of dealing with litigation is just so severe that from our standpoint as professionals, I think one of the best things that we can do for our clients is to help them avoid getting sued, avoid ending up in litigation. And I think asset protection is one of the best ways to do that. So when I think about how I can talk to you, fellow professionals, professional advisors, on what we can do to help our clients, I ask, how can we help our clients survive, not only survive, but also thrive during these uncertain, difficult times? And I think that one of the best ways we can do that, no matter what you do as a professional advisor, whether you're a CPA or a wealth manager or attorney, any kind of attorney, I think one of the best things that we could do is talk to them about asset protection. Perhaps the best example of the power of asset protection is a case study I'd like to share with you. John had a breach of contract claim against Acme Business. John sued Acme, and generally what happens is when somebody gets sued is they countersue and look for, if they will look for a way to countersue, and that's what Acme did here. Acme countersued John. John sued Acme for $100,000, and Acme countersued John for the $100,000 plus $1 million in punitive damages. John operated his business as a sole proprietorship, and Acme operated its business as an entity. In settlement discussions, Acme's lawyer claimed it didn't have enough assets to pay anywhere close to John's demand. So even if John prevailed at trial, John would not be able to get anything from them. And Acme's lawyer threatened to dissolve Acme and form a new entity to move forward with the business, even if John did win. So what happened? Well, the result was that because of that imbalance in their positions, John settled, and actually John, even though he was the plaintiff, ended up having to pay Acme a certain amount of money in order to get rid of the lawsuit. So that is the incredible power of asset protection. Even though you've got a client, the plaintiff, who may be the better witness, may have the better facts, may have the better law, at the end of the day, it is the party that is better positioned to end up prevailing even if that other party wins. And that's what asset protection can do for you. If you are the party that has better asset protection, that party has a decisive advantage in any settlement discussions. So what I've seen over the years as I talk to clients about asset protection is procrastination. It is something that when I'm talking to them, they appear to be interested in it. But what happens is that for whatever reason, they have other things going on in their life. They don't have an immediate problem, so they don't feel like it's something they have to worry about. So they don't go through with it. Then they feel guilty, and then later on they panic when something happens. They make excuses, and it just goes around and around. And a lot of people just don't get around to it. So like Jen was saying, initially, I can't believe how often that our clients who are high net worth, smart, sophisticated, wealthy, I can't believe how many times I deal with a client and it turns out that they do not have asset protection already. And again, talking to my fellow professional advisors who probably have a similar demographic of clients who are sophisticated, wealthy, and successful, for some reason, I can't believe how many times I see a client who is operating their business as a sole proprietorship or has real estate in their own name. But it happens. And so I do think that, especially right now with what's going on in this economy in these times, it is, in my lifetime, I've never seen a time of greater uncertainty in the economy and the future. We don't know how long this is going to last, and we don't know when it is, quote, over, what the economy is going to look like. Is it going to bounce back? Is it going to fall into a deeper recession? And so I think this is a very appropriate time for each of us to be talking to our clients about the importance of protecting yourself to prepare for the worst, hope for the best, but prepare for the worst. And one of the best ways to do that is to make sure that they have adequate asset protection. I'm going to give you at the end of my talk some questions that will help you have that conversation with your clients. So when I talk to my clients, what I'm going to do here in the time I have is to not go through a comprehensive discussion of asset protection, because that is well beyond the time that we have in this presentation. What I'm going to do is actually talk to you about the why, because I think that as professionals, what we can do is explain to our clients why this is something that they should not procrastinate about and they should take some action. And so I think the best thing that I can do for you is to give you these ideas, these concepts that you can use when you're talking to your clients. If you're seeing that they don't have asset protection and for whatever reason they're not taking action on it. So the analogy I like to use is football. So the reason that you need asset protection is a lot like the game of football. If, as a football team, all you have is an offense and all you're concerned about is putting points on the board, then the other team who has an offense and defense is going to win that game every time, because they've got defense that can respond to your offense. So a lot of our clients, business people, business owners, real estate professionals, a lot of them are so focused on putting points on the board, on making their business as successful as possible, or buying as much real estate as possible. And if they do that, that's great. But if they don't also have a good defense in their wealth management, then when somebody does come at them with some sort of a claim, they will not be positioned to defend themselves. And so it is essential for our clients to not only have a good offensive plan for their businesses, but also have a good defensive plan. And the best defense plan is to have a really solid asset protection plan. For many people, the problem is that they don't think that they're ever going to get sued. And the problem with that is, the reality is that you're more likely to be sued than to be injured in a car accident. And you're more likely to be sued than to lose your home in a fire. But we don't have to remind our client that it's important to get car insurance and to get insurance to protect your home. For some reason, even though the likelihood of a problem is even greater for getting sued, they don't get the asset protection to protect themselves. The problem is also that California is the most litigious state and the most lawsuit crazy country in the world, according to Time magazine. More than 1.5 million civil suits are filed in California every year. The Institute for Legal Reform, in fact, says that California is ranked 48 out of the 50 states in the lawsuit climate survey, 48th worst in terms of lawsuit climate. As a matter of fact, what they noted here in the last sentence is both Los Angeles and San Francisco made the list of cities or counties with the least fair and reasonable litigation environment. The president of the US Chamber of Commerce actually said, as to this point, California's lawsuit climate, that California's low ranking is not surprising given the fact that California juries are increasingly likely to award disproportionately large judgments in civil cases. And the effect on business is that 73% say their businesses suffered because litigation was very time consuming. And this is consistent with what I said at the opening, is that when I see successful business people, whether they own their business or they're real estate investors, the impact that it has, the opportunity cost, the time and the dollars that is required to deal with a lawsuit is a huge distraction for business people in being able to run their business. It's very time consuming. 64% say their business suffered because litigation was very expensive. In order to get through trial in California, the absolute minimum it's going to cost is $100,000, and it can easily get into 7 figures. And this is something that everybody who is contemplating litigation needs to understand, and we need to explain that to them. 61% say they felt more constrained in making business decisions generally because, again, if they don't know what's going to happen with the big lawsuit, it's going to impact everything else that they're doing in their business. 54% say they made a business decision they would not otherwise have made, again, because they have been pressured for other reasons dealing with the lawsuit. So they did not feel comfortable making certain decisions that they otherwise would have made in their business. And 45% say they changed their business practices in ways that do not benefit customers. The problem in California is so bad that they have what's referred to as a vexatious litigant statute. And the reality is that, at least in my experience, many of those vexatious litigants are not represented by counsel. They are what's called improper. They're representing themselves. And just because somebody's improper does not mean that they can't create a problem for you. We can tell you many stories where we've dealt with improper, and it does not mean that you can't take it seriously. So I tell you all of this because it's important to make sure our clients do understand the problem of not having adequate asset protection. As a business or real estate owner, you walk around with a bullseye on your back because you have double exposure. You have exposure to what we call inside and outside circumstances. First of all, let's talk about the inside. You must guard your personal assets from claims arising from your business and investments. So that's the inside claims. So for example, and everything I'm going to be talking about here, most of it applies to whether your clients just are business owners or if they also own real estate. There are contract-based claims, partner disputes, purchase and sale agreement disputes, disputes with lenders or borrowers, lease disputes, management agreement disputes, broker disputes, construction agreement disputes, easement disputes. And then there's other claims, personal injury claims, wrongful death, torts and crimes, sexual harassment, fires blamed on electrical wiring, toxic mold, lead paint, asbestos, hazardous waste, discrimination claims, regulatory and consumer protection claims, predatory lending suits, property damage and theft, default and eviction, foreclosure, and yes, bankruptcy. And don't forget, when you're a plaintiff, you're also a potential cross-defendant. So even if you're not concerned about getting sued, if you ever want to be in a position where you can assert your rights because you've been wronged and you want to be a plaintiff, you just have to understand that the first thing a defense lawyer is going to do is look for a way to countersue you. So for all those reasons, it's important for the client to understand that inside exposure. Now let's talk about the outside exposure. You must guard your business and real estate assets from claims arising from your other activities. So for example, do you drive a car? Do you own a home? Do you have children? Do you have repairmen and other invitees on your property? Do you have animals? Do you participate in sports? Do you borrow money? If you're not convinced you're at risk of getting sued, just think about things that can happen just walking around minding your own business. So for all those reasons, it's something that our clients really should be concerned about protecting themselves. But the next thing I want to talk to you about is probably the single most important fact and argument that you need to share with your clients. As a matter of fact, if you don't remember anything else from what I'm telling you today, this is the thing that you need to remember. You have to change your thinking about asset protection. Most people think about asset protection backwards. They think about it as a cure, and they can't think about it as a cure, because if they wait until they have a problem, if they wait until they've been sued before they want to get serious about asset protection, which is usually what happens, it's too late. It's too late because of something referred to as the Uniform Fraudulent Transfer Act. And there is a version of this act in each of the 50 states. And basically what it says is this, that if you wait until you know or have reason to know that there is a claim against you, even if the claim has not yet been asserted, then anything that you do to create an asset protection plan will be presumptively a fraudulent transfer, because it'll be presumed that you did that with the intent to hinder, delay, or defraud creditors. With the intent to hinder, delay, or defraud creditors. The reality is, therefore, that it's too late at that point for us to do much to protect you. I had a husband and wife call me the other day, and they were, I could tell from their voices that not only were they distressed, but they were older. And they said that they had just run over somebody, and fortunately the person, they didn't kill the person was still okay, but had been severely injured. And so they were certain that they were going to have to deal with a lawsuit from that individual. And so they asked me what I could do to help them, because they had no asset protection. And I had to tell them what I'm telling you right now. I had explained this concept of the Uniform Fraudulent Transfer Act and say, look, I'm empathetic. I'm sorry that you're in this position, but I've got bad news for you, that because you already know that there's a problem, that there's going to be a claim, there's nothing that I can do for you, because under the Uniform Fraudulent Transfer Act, it's not only the client that could be at risk for being found guilty of making a fraudulent conveyance, a fraudulent transfer, but also the lawyer who facilitated it. So if you, as the lawyer, try to help the client do that to create asset protection after you and they know that there's already a claim, then you as a lawyer also have liability. So it's something that you have to explain to the client, and it's something that the client needs to understand if they're going to procrastinate, because there is a cost to procrastinating. You can't procrastinate until you think you have a problem. And when the client understands this, if and when they understand this, this is the most significant reason that no matter what other reasons they have not yet decided to implement an asset protection plan, this should be the biggest reason why they should, because they can't think of it as a cure. It's a vaccine, just like what we're dealing here with coronavirus. You don't get, if you wait until you get the coronavirus, having a vaccine is not going to help. It's only just like the flu vaccine. You have to think of asset protection as a vaccine, not a cure. The reason that with all of that going on, with everything I just explained to you, that's why another way to think about UFTA, the Uniform Fraudulent Transfer Act, is to think about it as the ultimate financial tragedy accidentally. And I say accidentally because a lot of times people go ahead and form some sort of an asset protection plan after they already know there's going to be a claim, didn't realize that they were violating the Uniform Fraudulent Transfer Act. And not only did they not get the benefit of the asset protection, but then they get sued for violating the Uniform Fraudulent Transfer Act, which has a very serious economic consequence to them. So this is something that you really need to discuss with your clients, make sure that they understand it. The other thing that I hear frequently when I talk to clients about asset protection is the fact that they have heard, usually from their CPA or some other professional advisor, that they don't need any asset protection. All they need is insurance, and specifically umbrella liability. And that is something which is, first of all, which is incorrect, and I'll explain why. But it's something which is a deterrent to them, which can put them in a situation where, again, they're going to be vulnerable. So let's talk about why. Insurance is a false and partial solution, because when it comes to insurance, millions of instances of insurers arbitrarily lowering coverage, denying claims, and cancel policies is the reality that even though you have insurance, the insurance company can change your coverage at any point. I just got an email from my insurance carrier saying that because a property that we own is in a high-risk fire area, they're canceling our insurance unilaterally. And insurance companies can change the coverage in the middle of the policy as well. Happens all the time. Their business model is such that they take the premiums, but it's in their interest, obviously, to pay as few claims as possible. So because of that, any insurance coverage that you have is great, but it's not a guarantee that they're not going to be there when you really need them. If, for example, you do use an LLC, a limited liability company, as the asset protection for your assets, then it has certain benefits that insurance doesn't offer. It offers limited liability. It offers a deterrent to lawsuits. It offers tax benefits that insurance doesn't offer. And it offers the benefit of anonymity if it's set up the correct way. So insurance and asset protection provide two different things, two important benefits, which is why I always tell clients, you should definitely have insurance. Insurance is a form of asset protection. Just like you pay the premium on your insurance policy, the money you spend to set up your asset protection and maintain it, think of that as another premium that you would pay like your insurance policy, only this is a premium for a benefit that won't be changed in the middle of your ownership of it, and it will be there for you, assuming that you maintain it correctly. So I'm not saying that insurance doesn't make sense. It absolutely does. And I always tell my clients, in addition to getting as much insurance as you can reasonably afford and not overpay for it, that you should also be getting a proper form of asset protection. So that's why I think the solution to the problems that I've been talking about here for the last 15 minutes or so is for the clients to create, implement, and systematically maintain the wealth protection strategy that is right for them, right for you. Because there are many different forms of asset protection. We talked about LLCs, but there's also corporations, and there are other vehicles for asset protection. But the key word here is systematically, because the Achilles heel in any asset protection plan is how well it is maintained. Because I can set up an asset protection plan for anybody, but if they don't operate it correctly, then that asset protection plan will not be there for them when they need it. So when we work with our clients, we make sure we give them a memo and talk them through it and make sure they understand what they need to do to make sure that they are maintaining their asset protection properly, so a plaintiff's lawyer can't come in and try to pierce the corporate veil because they have maintained it like an alter ego, or they have been undercapitalized, or it's a sham, or whatever. So proper asset protection means proper maintenance as well. So there are 3 simple steps that clients can take to start protecting their assets right now. Number 1 is to appear broke. Number 2 is to create an estate plan. And number 3 is to use entities to hold title. Let's go through them quickly. When I say appear broke, what you have to consider is the psychology of plaintiffs' lawyers. When somebody comes to me and asks us to help them sue somebody, in the very first meeting, the conversation we have is, how do you know that the person you're asking us to sue is collectible? Because the last thing you want is to pay us to get a judgment for you against a defendant who is judgment proof. And then all you end up with is a nice piece of paper you can hang on your ceiling, which is a judgment that you can't collect. So what we do initially with every client is to have that conversation, whether it's a contingency case or a non-contingency case. And we do our best to determine if the defendant or defendants are judgment proof, or if they have some way to compensate. If it's a tort claim, then is there going to be insurance that might be available to pay for a award that we might be able to get. So if we see that the defendant does not have that indication of collectability, then we decline the case and we tell the plaintiff that we think it is a waste of their time, money, and effort to go after a defendant that is going to be not collectible. So what we want to do for our clients is make them appear to be non-collectible, to be broke. How do we do that? We do it with setting the properties up, setting the businesses up in proper entities. We'll talk about that in a second. The second step is to create an estate plan, but not just an estate plan. I'm not going to talk about all of that. What I'm going to talk about specifically from a point of view of asset protection is to make sure that you are working with your estate planning attorney to have them set up a trust to protect their children's inheritance with an asset protected trust. And that's a specific type of trust. And so I make sure that our clients have good estate planning. One of the services that we offer is estate planning. So you can just ask your clients if they do have first of all, if they do have an estate plan. If they don't have an estate plan, that's something that, again, is one of the biggest no-brainers when it comes to wealth management. You have to have an estate plan. But when you do have an estate plan, if all they have is a living trust, there is no asset protection in a living trust. There's a special type of trust that they need to have, which will be able to protect our children's inheritance. And so that's the kind of trust that they need from an asset protection standpoint. So how can your clients make sure that their financial statement is a deterrent instead of an incentive to creditors thinking of suing them? It's to form entities to hold title. As Nelson Rockefeller said, the secret to success is to own nothing but control everything. And what he was referring to is being able to own everything in entities, and that you own the entities. So you can control everything through the entities, but if somebody looks at your financial statement, they're not going to see any of those assets that are in the entities, because the financial statement is your personal financial statement and you don't personally own any of those assets. So the questions to ask your client. If you're sitting with a client, again, whether you're a wealth manager, CPA, attorney, whatever, I think these are questions that are helpful just as a way to give value to your client, to make sure, as part of what's going on today, to make sure that they're okay. And so you can ask them, first of all, do you have asset protection? And if they say no, then if not, why not? What's been holding you back? If they say it's just been too busy, I think I don't need it, and I'm not going to get sued, I've never been sued, those are opportunities for you to mention some of the things that I've talked about earlier about the potential that they could get sued. And then you can ask, may I explain to you why it's something you should definitely be considering? And then if they say they do have asset protection, I think it's a legitimate follow-up question to say, tell me what asset protection you have for all your assets. Because a lot of times they may say, well, for my business, I have a corporation, but they may say that they own a lot of real estate, but they own their real estate in their personal name. I've seen that happen many times, and they just, for whatever reason, maybe because all they have are single family properties, so they feel it's too small, which again is not correct, because again, they have inside and outside liability potential that they need to protect themselves from. If they do say, yes, they do have asset protection, then another follow-up question is, are you sure that you've been maintaining it correctly? Because again, the Achilles heel to any asset protection system is the proper maintenance. And I can't tell you how many times I have asked clients that question, have you been maintaining it correctly? And the response I get is a blank stare, and they have no idea what I'm talking about. Because for whatever reason, either their last lawyer didn't explain to them what they needed to do, or because they may have explained, but the client forgot, or the client got too busy, whatever. But that we have had to go back many times with many clients to go and try to reconstruct and repair mistakes they've made in the past in maintaining their asset protection correctly. And if the client is not sure if they have adequate asset protection, can I ask a few questions to try to determine if you are maintaining it correctly, if they're not sure they've maintained it correctly. And so you can ask them, do you have an alter ego problem? Are you paying personal expenses with your business funds, or vice versa? Are you signing all documents with the correct signature block? Are you doing things with your entity that are putting you in a situation where you're committing fraud? Things like that that prevent you from being able to use the asset protection to help you. Questions along those lines. In any event, so how can we help you? We provide asset protection services. We provide estate planning services. You can use us as a resource, or feel free to refer to us. And if your referral asks us to perform any service that you provide, we will make sure to refer them back to you for that. There are a number of topics I did not have time to cover today, talking about an LLC versus corporation, the power of charging orders, how many entities to use, what to do if you have a loan against your property, single member LLCs, Delaware series LLCs, land trust topics. These are all topics that are an important part of an initial conversation with the client about asset protection, and we spend a lot of time talking with them about that. For a more detailed free webinar discussing all these and more, you can email me, jeff@lermanlaw.com, and I will send you a link to that longer webinar. And in that webinar, I talk about all of those topics to give you more information and put you in a better position to have an important conversation with your clients on this topic. But again, just to remind you, the most important thing to take away from this is to tell your clients, vaccinate now before it's too late. Get your asset protection in place before you know that there's going to be a claim against you. And with that, I thank you for your attention, and I pass it over to Phil Diamond or Jen to introduce Phil.
Thank you so much, Jeff. That was very interesting. And a lot of that I agree with, because I see a lot of the UFTA problems in bankruptcy. So the next speaker we have is Phil Diamond, and I'm really interested to hear what he has to say about commercial leases and how this is all going to play out through COVID-19. So Phil Diamond is also with Lerman Law Partners.
Philip?
Jen, can you hear me okay?
Yes, we can, Phil.
Yep, we can hear
Okay,
you.
great, thank you. Okay, so let's get started. First of all, I'm going to do my best to get through this in about 15 minutes or so. There's a lot of ground to cover, but I will do the best I can. Also want to mention right from the beginning, I'm assuming that those of you on the line may be wondering why everyone else has a video image and I don't. You see a photo of me there. It turns out that it's not only personal protective equipment that is in short supply worldwide, but so are webcams. I ordered one about 6 weeks ago. It was supposed to have been delivered yesterday. It's now been delayed until July. I expect perhaps some of you are experiencing that as well. And another reason that I mention that is by way of disclaimer, the photo that you see is a bit dated. And the reason I mention that is just by way of background, and I'm not going to be spending a lot of time on this, but I've been a practicing lawyer for about 45 years now. My focus is on real estate disputes and transactions, litigation, and the insurance issues that arise out of them. I've been of counsel with Lerman Law Partners about 15 years now. I'm also a mediator and arbitrator. And as Jeff is also an investor and a broker, I am also a licensed broker and a real estate investor. I'm also a commercial landlord and am dealing with some of our commercial tenants right now on some of the issues that I'm going to be talking with you about as we go forward in the presentation. So first, what are we going to be talking about in the next 15 or 20 minutes? First, can I lease my commercial property during the crisis? And again, when I say my, I'm referring to commercial landlords. Secondly, what do we do if tenants stop paying rent? And then finally, is there insurance available for the loss of income that results from the crisis? Also want to mention right from the beginning that I'm going to be talking today solely about commercial and not residential properties. I'm not talking about multifamily, for example. There are a whole other set of issues that are involved with those that are beyond the scope of this discussion. Secondly, there are many, many areas of uncertainty on the things that we're going to be talking about, both because many of the regulations are somewhat unclear and also because, as Jen mentioned at the beginning, things are changing literally daily. Next, I also want to mention from the beginning that what I'm going to be talking about is going to be by and large judgment calls. There are no right or wrong answers to the things I'll be talking about. And then lastly, to repeat briefly what Jeff mentioned, we are not giving legal advice in the webinar. We will be happy to discuss more of these things in detail with any of you or your clients at a later time. So to start, can I lease my commercial property during the crisis? The short answer is yes, you can, but there are a number of things that I'm going to suggest that as commercial landlords you consider. The first is timing. Is this the best time for you to be thinking about doing it? For example, the potential tenant pool right now may be reduced to those who would be operating the quote essential services as that is defined under federal, state, and local guidelines. And from a practical standpoint, think about what it takes to get a new tenant into a property. It may take some tenant improvements to be performed. Are there contractors available to do that? And are the contractors themselves bound by the shelter-in-place orders and therefore unable to do that? Same thing with regard to movers. Are there movers available? Another thing I would suggest that you as a commercial landlord consider is, are there restrictions on marketing the space that you're trying to lease? And the first question there is, can you use an agent? The short answer is that yes, you probably can, but there are a number of restrictions. I start from the standpoint that residential and commercial real estate services are both considered, quote, essential under the U.S. Department of Homeland Security guidelines, which is the set of essential services that is adopted under Governor Newsom's March 19, 2020 shelter-in-place executive order. But that said, there are a number of local jurisdictions, cities and counties that have a much narrower definition of what is essential. One example is San Mateo County, where real estate service providers are essential only with regard to residential properties and only if it is, quote, absolutely necessary at this time to provide those services. And one of the examples that the county website gives is if the transaction involves a healthcare professional moving into or out of the county. And that means for commercial real estate, for all intents and purposes under that situation, if an agent is able to work for you, that agent likely is going to be able to do so only from their own residence under the shelter-in-place order. Can you use property? On-site showing prohibited by law? And the answer to that is it depends on the local jurisdiction. The state and local orders require everyone to stay at home. That's the starting point of the discussion. Everyone has to stay at home unless there is an exception. And there are exceptions for real estate, but that is of real estate, such as brokers and others who service the industry, that as opposed to the actual lessors or lessees or buyers or sellers of the property. And there are some local orders, as I mentioned, like San Mateo County, that make it clear that commercial real estate is not, quote, essential, close quote. And one exception to that might be if that business is conducting an essential business. So in any event, if you are able to actually show the property, it is critical that you use best practices in doing so, and the guidelines for those best practices are set out by the CDC and by the California Association of Realtors Best Practices Guidelines, which essentially say that if you can do it, make it a virtual showing rather than an in-person showing, if at all possible. And there are a number of other guidelines as well. And what I would suggest in making the decision as to whether to actually show properties in person is to weigh the risk of the need for speed, so to speak, in leasing the property against, first of all, potentially contaminating the property by bringing somebody who is infected into it. Secondly, then the question would be, would that become a disclosure item to other potential tenants? There may also be a risk of spreading the virus among people who are on the property if there is anybody else in there at the time, and there really shouldn't be. There may be potential liability issues that could arise out of it as well. And in that regard, there is a coronavirus property entry advisory and declaration form that the California Association of Realtors has developed for a residential property. It could be used for commercial as well. That basically has everyone signing a disclaimer and a disclaimer of liability, as well as a number of other things before being allowed to enter into a property. So in the interest of time, I want to turn now to the next issue, which is what do you do if, as a commercial landlord, your tenants stop paying rent? Ben has covered a number of these things already, so I'm not going to spend a lot of time on this other than to say, first of all, the starting point is to determine what does the lease provide? What are the tenant's rights under the lease? Does the lease provide for what's known force majeure, or the impossibility of performance? Most of you probably know what the term force majeure means, but just by way of background, the dictionary definition is that it means an unforeseeable circumstance that prevents someone from fulfilling a contract. And in the case law in California, the force majeure cases arise out of, for example, things that happened during World War II that made it impossible to perform contracts. The same concept is there for purposes of the common law and the case law and statutory law in California. And it's basically, if something becomes impossible to perform, that can be a defense to a suit to enforce the contract. And then the next step is, what are your, as the commercial landlord's legal rights under the lease? Are you given the option of terminating the lease and suing for damages? Are you given the option of continuing the lease in place and then trying to collect rent as it becomes due? Then the next set of issues that I would suggest that the commercial landlords consider is, what are their legal rights under federal, state, and local coronavirus orders? As has been mentioned earlier, there's a statewide ban on residential evictions where the inability to pay rent is due to coronavirus. And the question then becomes, is there a moratorium on commercial unlawful detainer actions and evictions in your jurisdiction? And as Ben alluded to earlier, there are many local jurisdictions that now prohibit both residential and commercial unlawful detainer actions if the non-payment of rent is due to circumstances related to the virus. And again, the rent obligations are deferred, they are not eliminated. And that then begs the next question, which is, are the courts open for you? And as Ben also mentioned earlier, the short answer to that question is that the state courts are pretty much closed for all civil matters, except in the case of some major emergencies, for example, a domestic relations restraining order. And under the court emergency rule 1 of the California Rules of Court that went into effect on April 6th, all courts in California are in any event now prohibited from issuing summonses on any unlawful detainer action until 90 days until after the emergency is declared to be at an end. And then a couple of other things that I would quickly suggest you consider in deciding what to do if a tenant stops paying rent is the practical difficulties of getting another tenant in place. And that follows up along the lines of what I talked about a moment ago about people actually being able to go out and do things that they otherwise could have done. And then perhaps even more importantly, ask yourself the question, is this a tenant-landlord relationship that you want to preserve? And if the answer to that is yes, then the rule of thumb from my perspective is work with your tenant to work out a creative solution to the problem. You might want to ask for financials to support their inability to pay. You also want to make sure that the tenant is taking advantage of all government resources that are available to it. You also should consider that there are possible structures of an agreement for a rent deferral on which you can get creative. For example, you could structure an agreement where the tenant repays the deferred amount at the end of the lease term. You could extend the lease term and then have the tenant repay in small amounts, incremental amounts over the entire term of the lease. And there are a number of other things that could be explored as well. And perhaps most importantly, make sure you are coordinating with your lender as to what it is that you are doing with your tenants. That in turn begs the question, should you reach out to your tenants before they reach out to you to ask how they're doing? And again, this is a judgment call, and it depends upon your relationship with the tenants, in my view, and your view as to what their abilities might be to keep the lease in place going forward. If you are also at the same time trying to work out an arrangement with your lender, the lender may look askance at you volunteering to your tenants and going to them before they come to you and telling them, hey, look, we're going to defer your rent, because you never know, they may not have even asked for it. So again, the question is to make sure you maintain communication with both your lender and your tenants and make sure that you are all on the same page. So with that, let's turn then quickly to the last of the three topics I wanted to spend a few minutes covering here. And that is there insurance available for the loss of rental income? The starting point for that discussion is what is business interruption insurance coverage? And in a nutshell, business interruption insurance covers lost income resulting from either damage to the policyholder's own property, and that's typically referred to as business interruption coverage. Secondly, damage to property of a customer or a supplier, and that is referred to as contingent business interruption coverage. And that, by the way, could pertain to tenants if they have suppliers or customers who have stopped providing them business because of the crisis. And then the third, business interruption insurance covers lost income from a government action such as an evacuation order, and that's typically referred to as order of civil authority coverage. Now, those coverages can be either in a separate standalone insurance policy, but they usually are part of an underlying commercial property insurance policy covering the property. So again, the standpoint to begin with, I should say the starting point is read your policy. And I should also mention that these issues, and we'll come to this in a moment, are not clear cut. And these are typically issues that are extremely difficult to learn the answers from just by reading the policy. So what I would suggest to you as professional advisors is that your commercial landlord clients would be well served to have their policies reviewed by a professional in the industry, whether an insurance professional or a lawyer who specializes in these things, because these are issues, the answers to which a lay person may not be readily able to obtain. So then the question becomes, okay, you've read the policy, you've had it referred to or reviewed by a professional, and you have now made a claim on that policy. What is the insurance company's probable response going to be? Jeff mentioned earlier that insurance companies are real good in collecting premiums, but they've got a business to run also. And while their mission in life is to pay out legitimate claims, the key word there is what is a legitimate claim. And from the standpoint from an insurance company, the likely response is going to be, first of all, that all forms of the business interruption coverage that I mentioned require some form of property damage before that coverage will kick in. So that begs the question then, is there property damage in a property resulting from the fact that there is coronavirus in that property? And that then in turn begs the question, how do you know the virus is there? And if it is there, let's assume it's on a surface, is it being on the surface, does that qualify as, quote, direct physical loss or damage to the property? There's no right or wrong answer to that, and there are appellate decisions in California and elsewhere that deal with situations somewhat analogous to that, but as yet there is no appellate guidance as to whether the virus itself being on a surface constitutes direct physical loss or damage. The next issue, though, that then raises is, let's assume that it is damage. All of the business interruption policies provide for what's called a period of restoration. And what that means is that the policy will provide you with the lost income coverage during the reasonable amount of time it takes, or it should take, in order to get the property back into proper condition. So in the case of a coronavirus, how long is that period of restoration? Is it as long as it takes in order to get the property completely decontaminated and ready to be used again? Or is it something else? Again, we don't know the answer to those questions, but it's certainly something that the insurance company is expected to raise. And then finally, there are exclusions that may apply even if there is a physical damage that is covered. There may be exclusions that would in turn take that coverage out of effect. Now, for many years, there have been exclusions that have prevented coverage for contaminants or bacteria or things of that nature. And following the SARS epidemic in 2003, insurers also started to exclude coverage for viruses and other communicable diseases. So if that exclusion is in the business interruption policy that you're looking at, likelihood is that the carrier is going to deny coverage based upon that exclusion. And whether there would be some way of getting around it would have to be determined by looking at the underlying facts, looking at whether there is something else that you might turn to, but it's going to be an uphill battle. I would lastly mention that it is also worth looking at whether your tenant has business interruption insurance for the same reasons as whether you as a commercial landlord has the insurance. And if they do, the tenant should be urged to make a claim on that policy as well. So with that, I would say then in conclusion that the novel coronavirus has certainly presented commercial landlords and tenants with many novel issues and challenges that we are all just beginning to face and to deal with. And if you or your clients have any questions or need assistance, we are here to help. You have our email address on these slides. We will be emailing these slides to everyone who attended, and we will be happy to speak with you directly in follow-up phone calls. And Jen, with that, I will turn it back to you.
Thank you, Phil. Helps if my microphone's unmuted too. So thank you all for attending. We did answer a few questions in the Q&A, and thanks for staying a little bit longer than 1:30 as it was scheduled, because we had lots of good information. So as Phil mentioned, we will be emailing out a link to the recording itself, along with the slides from each presenter, and along with our contact information. So if you have any questions, feel free to reach out to the professionals in this room. All of the panelists, thank you for being here. And any closing words from you guys? Are we all good? Okay.
Jen, I would just say thank you for acting as moderator and for coordinating this event. And it's been a pleasure participating.
Yep.
Thank you.
Absolutely. Thank you, Jen.
No, I think this is great information for all areas of what we're doing with small businesses. So again, thanks everyone. If you have questions, feel free to email us, and have a good Thursday and stay safe out there. Thanks.
Thank you.